Hello, everyone. My name is Aisha Mane, and I am ICCF representative for Senegal and West Africa. I'm also managing counsel at Huda Law Firm based in Dakar, Senegal, and Abidjan, Ivory Coast, where I'm currently seating. So, who is in charge of international arbitration in my region? Before I answer this big question, I would like to make 3 points regarding one, the role of major institution, two, the role of the state, and three, the role of local practitioners. Before I begin my presentation, I would like to tell you a little bit more about what OHADA is for people that are unfamiliar with it. So OHADA is an organization for the harmonization of business law in Africa. It is composed of 17 member states, including Senegal and Ivory Coast, where I practice. And in our region, all of the states share the same laws and regulations, which are enacted via regional treaties called Uniform Acts, which touch on various business areas, including arbitration, right? So let's talk about my first point regarding institutions. So the institution we'll talk about is the Common Court of Justice and Arbitration. So the CCGA was created in 1999 through the Uniform Act of Arbitration, which was subsequently amended in 2018. What it did is that it created an arbitral institution that would be pretty much in charge of dispute resolution for the member states. So through the patronage of the member states, which have various regional and international transactions, which include CCGA arbitration clauses in their contract, the court was able to grow to a very important role within the region, which also means that it now has to answer to some questions regarding its efficiency as well as transparency, something that it is actively working on. Now we must also talk about some local arbitral institutions that we should highlight because they've done a great job in terms of growth and efficiency. And I will highlight CAMCO, which is in Burkina Faso, as well as GICAM in Cameroon, that are doing well. For my second point, we'll talk about the role of the state. Africa, and OHADA in particular, has been a recipient of a lot of foreign direct investment, which means that the states have a vested interest in making sure that create a business environment through its laws, through its dispute resolution that is attractive for foreign investment. It's a critical aspect of it. One thing that we will have to say is that through OHADA and its uniform laws, the states have done just that. We will also highlight that 14 out of the 17 states have adopted the UN Convention. So this is a great aspect of arbitral award enforcement. Another great component for enforcement is the fact that any arbitral award that was issued within the OHADA region benefits from nearly automatic enforcement. And this is comparable, for example, in terms of advantages and enforcement protection is comparable to, for example, the ICSID Convention. These types of positive trend has been adopted by the member states. And we can see that through even the training of judges to make sure that they maintain this type of positive movement towards creating a positive dispute resolution environment. Now let's talk about the third prong, who I believe is already in charge and who needs to take more charge, really, and that is the local practitioners. So in my view, the local practitioners really are in control in terms of doctrine. So one issue that we have in our jurisdiction, especially the Francophone ones, is that there's not enough of essentially publishing of jurisprudence, right? So what local practitioners are in control of is the doctrine, is the dissemination of more of this doctrine in order for us to enrich our legal framework. This is especially important when we look at the fact that it is not unheard of that in an arbitration where, let's say, the applicable law is Senegal, French jurisprudence would be used as an example. So this type of of, let's say, desert in legal desert needs to be remedied. And I believe that the people in control of that are the local practitioners. So on that note, I would like to say thank you again for having me. And I do hope that in the future, more local African practitioners will be more in control. Thank you very much.
Hello, good morning from Israel, and thank you for the organizers of New York Arbitration Week for inviting me to address this esteemed audience. My name is Shai Shovit, and I am a partner at Gornitsky Law Firm in Tel Aviv, Israel. In addition to my work, I also hold different positions in international arbitration institutions such as the LCIA, the ICC, UNCITRAL, and the Israeli Institute of Commercial Arbitration. I am sorry I was unable to come to New York this year due to other previous commitments, but I have been an enthusiastic supporter of New York Arbitration Week since its inaugural event in 2019, and I hope to be there in person again next year. I was asked to discuss developments and innovations in the Israeli international arbitration world, which has been rapidly growing in the last decade, with the market massively changing and firms large and small focusing more and more on developing their arbitration practice. Israel arbitration laws are outdated. Our main legislative piece relating to arbitration in general, including international arbitration, will soon celebrate its 55th anniversary, and despite a very pro-arbitration judiciary and the common law tradition of the courts, developing the arbitration world through case law and precedents, the arbitration law of 1968 is no longer suitable for purpose. This has made the courts the landlords and real owners of the arbitral proceeding. Issues such as arbitrability, appointments of arbitrators, interim measures, and others, which are not thoroughly regulated by the current legislation, were developed and in some aspects even created by the courts in order to adapt the legal framework to the developments in Israel and abroad. However, not all is bad with the current legislation, and one unique and very effective feature of the existing law was a set of default arbitration rules, which applies to every arbitration unless the parties opted for another set of rules that would apply: ICC rules, LCAA rules, ICDR rules, etc. This unique feature has saved substantial amounts of legal fees and litigation costs for ad hoc proceedings, and in my humble opinion, should be considered in other jurisdictions as well. But the outdated legislation and its shortcomings have finally led the legislator in Israel to try to amend the current legislation and adopt the UNCITRAL model law for international arbitration. The aim of this change is not only to adapt the legislation to the modern international arbitration proceedings, but also to harmonize the arbitration law of Israel with those of the other jurisdictions which have adopted the model law previously, and to build on their accumulated experience in applying its provisions. Therefore, in 2021, the Ministry of Justice in Israel published a draft bill for international commercial arbitration, which is anticipated to be discussed and voted on in the coming months once the new government in Israel starts working. The harmonization of the new legislation with other jurisdictions is a key feature of the new draft bill, and not only that the Ministry of Justice avoided any changes that might detach the draft bill from the UNCITRAL model law, but it's specifically enshrined in Section
Well, we still have some people trickling in, but I know that everyone is eager to hear this fabulous panel and get to the other fabulous social events this evening. So we'll get started. And I am not part of the fabulous panel, so I won't take too much time. I just wanted to say welcome to Chaffetz Lindsay. My name is Greta Walters, one of the partners here. And I would just like to say thank you for everyone for coming. It's really nice to see so many of you again in person after so long. And I know we have a huge group joining us virtually as well. Chaffetz Lindsay is a proud sponsor of New York Arbitration Week this year. And we're absolutely thrilled, as I know all of you are, to have this great panel with us today. But I think that's enough for me. So I will turn it to Kabir Duggal, part of the fabulous panel, and get things going. So thank you very much.
Thank you, Chaffetz. I guess we still say good morning, good afternoon, since this is virtual, but to everyone in the room, thank you for coming. Good night. You are the lucky people who made it in the room. There is a waiting list of 140 people. Give it up for them. This is the scholars panel. So we're really going to be hearing from the best that New York has to offer, right? And if you're one of those people who believe arbitration is all about party autonomy, it's parties can do magic, parties can agree on everything, they're going to tell you what the limits are. So no pressure, but it's going to be a lot of fun. We've gotten 4 professors. I'm going to read them out alphabetically. It's Professor George Bermann, Columbia Law School. Please Google them. We will otherwise be here till tomorrow. However, I am going to share a fun fact about each of them. Professor George Bermann is married to Professor Sandy Bermann, a professor of comparative literature at Princeton. And 10 years into his marriage, he discovers that his wife is also Miss Chicago. And I think that is pretty special.
Yeah, you've got to add that she had hoped I would never know.
Yeah.
That was the line.
So Professor Bermann's going to talk to us about limits of party autonomy in the composition of tribunals. Can I appoint my dad? Does it matter whether my dad likes me? Those kinds of issues. We're then going to have Professor Pamela Bookman from Fordham Law School. Professor Bookman plays the viola. You know, whenever you say you can play an instrument or dance, you know we're going to ask you to do that. So at some stage during the New York Arbitration Week, you're speaking tomorrow?
No.
Day after? Okay.
Only speaking
Today, okay. Catch her during the arbitration week. Professor Bookman's going to talk to us about arbitrability as the limit on party autonomy. So that's going to be a fascinating topic. Next to that, we have Professor Giuditta Cordero-Moss, University of Oslo, but spending this year with us at NYU. We can ask you to do yours here. The fun fact, she's trained in classical ballet. So during the reception, and Professor Cordero-Moss talks to us about public policy as the limit of party autonomy. Last but not least, Professor Franco Ferrari. So you know it, both the gentlemen, Professor Bermann, he's a mentor, a father figure. Professor Franco Ferrari was my professor. I do feel some anxiety to perform.
Yes, you should.
He's the author of the book, Limits to Party Autonomy in International Commercial Arbitration. You can buy it from Amazon for $103. But very important.
I don't get royalties, unfortunately. So I just want to make sure you know.
Amazon very helpfully tells us you can see bestseller. So that's kind of, I don't know if you know this.
No, I
You're on the bestseller list.
I can't even read it. But
And he's going to talk to us about mandatory institutional rules as limits of party autonomy. The way we are going to do this is each speaker talks to us for 10 to 12 minutes. We'll go in this order. After that, you can ask them anything about party autonomy, for all the students in the room who have been asked difficult questions, revenge is wonderful. So we will judge you on how difficult your questions are. But before we do that, give a round of applause to our awesome panel, and Professor Bermann, take it away.
Okay, thank you, Kabir, and thank you, Chief Lindsay, for hosting us today. Can you hear me? Good, thank you. So my angle on autonomy is really not as intellectually rich as that. We'll hear about arbitrability, we will hear about mandatory rules. This is sort of mundane, but why do it? Well, there may be no decision that council and parties make that is most imbued with the principle of party autonomy than selection of arbitrators. So even though there may not be a great deal of the things I say that will be of enormous intellectual interest to you, just do bear in mind that party autonomy in the selection of a tribunal is arguably the very raison d'etre of arbitration. That's a little bit of an exaggeration, but the ability to choose your own tribunal is among, I think you'll agree, among the reasons why arbitration is as attractive as it is. So it's because of the fundamentality of autonomy in this sphere that I've undertaken to think about it. What I want to say at the outset is that the sources of the limits, and we'll hear this from everybody, I think, the sources of the limits are multiple. And you will see it very clearly as I quickly go through this. Those limits, such as they are, may obviously come from the law of the place of arbitration. That's where you should look early on for what the limits are to which you're subject. Institutions have ways of confining arbitral autonomy with respect to the composition of the tribunal, though not very stringently. I would say any court before which an arbitration agreement or an arbitral award comes has an opportunity to decide that you have exceeded the limits of party autonomy in what you've done. So the sources, some of them in the future, some need to be anticipated, are multiple. But I think what is going to be most interesting about this, if there's any interest to it, is the parties themselves. To what extent can the parties themselves limit their party autonomy? Or putting it differently, to what extent can the parties exercise party autonomy to limit their party autonomy? That may sound a little counterintuitive, but there's something to it. So what I'd like to do is divide my very short remarks into three categories that run into one another. The first one is, well, how free are the parties in determining who will adjudicate their dispute? What can they do? Now we get to the more interesting things. What can and do states do? Imposing conditions on the exercise of party autonomy in the composition of the tribunal. I'm not going to go into what institutions do because they do pale by comparison. But what I'm going to spend most time on is what can parties self-impose? And you might say, why do you care about this if the parties have self-imposed? Well, they may have self-imposed, but one of the parties may regret that they have self-imposed and may think that the violation of that self-imposition might be a ground for challenging an unfavorable award. So I'm going to start with what can parties do? Well, your presumption should be that parties are free. to name or to limit, subject to what I will say in the third part, to confine their selection of arbitrators, to place conditions on the arbitrators they will have. And you know this perfectly well, so I'm not going to dwell on this. Obviously, we know this. The parties are free to prescribe the nationality of the arbitrators who will, presumably they have a reason. We can talk about a little bit later. They certainly can prescribe the experience or education that is required to be eligible to be named. They certainly can and do require proficiency in a language. They can and do, if they wish, make it clear that arbitrators do not need to be lawyers. They can perfectly welcome engineers, economists, or anybody else. I mean, I could go on and on about what parties we assume parties can do. I like to say to my students, I don't think I said it this year, but I actually think you can limit your arbitrators to redheads. I don't see any reason why you couldn't, but we'll have a discussion later, right? So I'm putting this on the table. Confining your pool of arbitrators to redheads. Okay, so parties can do a lot. That's what party autonomy means. They have the world open to them. Now my second part, and this will not even take 10 minutes. What can and do states impose on parties? Now things get interesting. And I put them into two categories, not very interesting categories: structure, the tribunal structure, and personal individual characteristics of individual arbitrators. Now, most institutions are liberal about how many arbitrators you want to have. But if I'm not mistaken, the ICC likes it to be 1 or 3. I stand to be corrected. So, you know, if that's the case, then you can only have 1 or 3 arbitrators, if that is the case. There are some leading cases in the United States, and students of mine in the room will remember this, where Italy prohibited tribunals that had even numbers of arbitrators, and the agreement is invalid if the number of arbitrators chosen is an even number. There are countries, and I lifted an article from the book that was edited by Franco. So if you'd like citations to my points, they're all there. You'll be surprised to know that almost everything I say, some country has done. Okay, some country has chosen to do what or institution has. Institutions have lists, and sometimes they're not limitative. Sometimes they are limitative. I recall in Brazil where you could be an arbitrator when you're not on the list, but you need to go through some process. Does that ring a bell? You have to go through some process. And so that's a barrier, if you will. I wanted to give you one example of an institutional barrier. From structural point of view, that's all I have to say, but I may be omitting some things. On the level of personal characteristics, states do impose some things, and I think you won't be surprised, but they impose them in very variable numbers. Some of these I have only one country that could be found that did it, but some are quite common, and they're all known to you. But let's put them on the table. They can impose nationality. Now they might impose a nationality, or they might actually say the arbitrator cannot have the nationality of either party. So it can work both ways, okay? You must have a nationality, X, or you cannot have the nationality of either of the parties. Capacity, that's almost definitional, but I think it's assumed that arbitrators need to have capacity. Age is an interesting one. It's so close to home. You know, in Bangladesh, you cannot be named as an arbitrator after you've reached the age of 76. Now, you'll be very glad to know that there is an understanding in Bangladesh that if you were appointed before you were 76 and you turned 76 during the arbitration, you do not have to step down. Okay, so I assume we also can envisage a minimum age of arbitrator. I don't know that I've seen it, but it's perfectly conceivable. More in the realm of possibility, there are a lot of research went into this, by the way. There are a lot of countries, or a number of countries, that disqualify people from being arbitrators if they ever had a criminal conviction, or if they are bankrupt. I don't know if they were bankrupt is a problem. If they were a criminal, it is a problem. But and the main one, of course, the state can require that the arbitrators be impartial and independent. And that's a topic for a conference unto itself. We're not going down that road here, but that's probably the most significant one of all the ones I had to mention. I will add, though, two that are interesting. I'm going to give you examples. You like examples, don't you? Jordan requires an arbitrator to have not necessarily be a judge, and in fact, some countries prohibit judges, but you have to have the qualifications to be a judge in order to be an arbitrator under Jordanian law. So that's really it depends how you define the qualifications to be a judge. I mean, if they're broadly construed, it's not much of a barrier, but that depends upon the country. And the most controversial of all is religion. And that's a topic. But I understand that, for example, in 2012, Saudi Arabia reformed its law, which before that time required arbitrators to be male and Muslim. And that is, I'm told, no longer the case. But it's something you want to look into, particularly in that part of the world. There may be limitations imposed by Sharia law that country's courts will enforce. So there are restrictions coming from the states themselves. I don't think I've exhausted them. I think I have identified the most, let me say, the least improbable rather than the most probable. What I find most interesting, and I rather expect you will too, is what the parties can't confine themselves to. To what extent can they not exercise party autonomy to limit their party autonomy? I find that's an interesting way to put it. So there are some narrow examples, narrow gauge, and there are some that are really, they're things for us to talk about, time permitting, others not. I don't know that it's ever articulated, but it's assumed, unless the law says otherwise, that an arbitrator must be a natural person. I think it's assumed. 1 minute. Oh, I got to pick it up. Okay, so I lied about my time. Okay. All right. So religion could be something you put in your arbitration agreement as a requirement. That was litigated in the UK in a very well-known case, Giuditta versus Hashwani. I recommend it to you. it was upheld. The limitation was found to be defensible. But to pick up the speed, the second thing I'd like to mention is, in fact, this is where I'll end in interest of time. This is more theoretical than real, but it does raise a question about the limits of party autonomy, and that's asymmetry. The asymmetry in the composition of the tribunal. I really don't think that arises very often. I hope someone, if someone has had this experience, will hear about it. But asymmetry is frowned upon. And the question commonly arises, why shouldn't the parties be able to select an asymmetric panel? Or does party autonomy stop at that point? Does the law not want to enforce awards that come from tribunals that were imbalanced? Even if the parties agreed, and even if there wasn't a stronger and weaker party, but it is very hard to believe there wouldn't be a stronger or weaker party if the parties reached that agreement. I think you will agree. I will end on a light note. A judge who addressed the question of the limits on party autonomy observed that you cannot empanel 3 monkeys. This is in the opinion. You cannot empanel 3 monkeys. And I want to just dig into that a little bit. It reminds me a little bit of Judge Kosinski, some of you may have known on the Ninth Circuit, who said you can pick whatever decision-making thing you want, whatever you want to do, but you can't make the outcome depend, you know this, on the entrails of dead fowl. Now, if that's not ringing a bell, that's how disputes evidently were decided by examining the intestines, if birds have intestines. I don't even know. There are some limits. I would just close by saying, I suppose if we take the monkey example and the capacity example, we could probably conclude that we expect a rational decision maker. I think that's what the learning from that is. So that's about all I could find in terms of limitations on party autonomy.
Give it up for Professor Bookman. Okay, monkeys are not. Professor Bookman, tell us about arbitrability and the limits in party autonomy.
Okay, thank you so much. That is a tough act to follow. Thank you all for coming, and to those of you online, thank you for zooming in. It's really an honor to be here on this panel, and thank you for the invitation. And thanks to New York Arbitration Week and to Chaffetz Lindsay for hosting. I'm really excited about this. So I'm going to talk about different ways in which questions of arbitrability and related questions of illegality it can interfere with the promise of party autonomy. And we know about the idea of arbitrability, and we may or may not always think about it as a question that relates to a limitation on party autonomy. But if you think about it, it is, right? So parties, the question of arbitrability refers to the kinds of issues or claims that a contract can assign to an arbitrator. And parties do not get to decide this question entirely on their own, right? If that were the case, then we would get to decide all of our divorce issues and all of our criminal issues and all of our, I don't know, trusted estates issues entirely to an arbitrator. And those are not all arbitrable, and they are certainly not. And the rules about what is arbitrable and what is not arbitrable is also inconsistent around the world. So in the United States, we think often that everything is arbitrable because we have such broad conceptions of arbitrability, right? I mean, even questions of consumer law, consumer contracts, employment contracts, all sorts of contracts that in other countries may not be subject to arbitration for all sorts of public policy reasons, are arbitrable in the United States. And indeed, the United States has long sort of led the way in recognizing slowly over time and continuing to recognize more and more different types of issues to be arbitrable. So antitrust issues, of course, famously are arbitrable, and in the United States recognizes that that antitrust issues are arbitrable, and that has led to many other countries also, or I don't know, led to, but many other countries also recognize that by now, but not all. And similarly, securities litigation, what we think of as securities litigation, securities issues are now arbitrable in the United States, but not everywhere, right? So in German securities litigation legislation restricts the availability of arbitration to commercial cases in which both parties are established businesses or companies, right? So these are laws that restrict what might otherwise be conceived of as party autonomy to enter into a contract that has an arbitration clause that would ordinarily be read to assign an issue to arbitration, and yet does not because of the overarching laws on arbitrability. One issue that I think is very interesting with regards to arbitrability and limiting party autonomy are issues that arise out of insolvency and bankruptcy, right? So in general, bankruptcy itself is usually non-arbitrable, and you wouldn't sort of ex ante thinking about arbitration as as promoting a core of party autonomy necessarily understand all of bankruptcy to be non-arbitrable, but that is the structure of the law, certainly in the United States and in many other places. And bankruptcy can also, under certain circumstances and under certain countries' laws, restrict or interrupt the arbitrability of certain contract-based disputes that otherwise would be arbitrable had both of the companies remained solvent during the pendency of the arbitration. So there's a potential for significant differences in approach. The Polish Electrum company example, right, in which two different arbitration panels came to two different countries came to two different decisions about whether a party. So if you have an arbitration and one of the parties during the course of the arbitration becomes insolvent, does that make the does that instruct the arbitrators that they should cease to arbitrate because they have the dispute has become no longer arbitrable? It started off being arbitrable, and then because one of the parties became insolvent, it became a non-arbitrable. And in that case, right, two tribunals in two different jurisdictions came to opposite conclusions about whether the arbitration could continue following the opening of insolvency proceedings in Poland, and it became a question of interpreting Polish law. And the Swiss Supreme Court then upheld the award of the arbitral tribunal seated in Switzerland, which had declined jurisdiction over election after it was declared insolvent. But then we also have differences of opinion about that issue, and it has become, it's a controversial question, right? So arbitration can be seen as incompatible with insolvency, in part because the essence of arbitration is the resolution of private claims out of court, and insolvency frequently takes the form of collective processes that are meant to draw in many different parties, including some of whom may not have agreed to an arbitration. But the point is that the interaction of insolvency law, bankruptcy law, and arbitration law can lead to a limitation on what creditors and debtors might otherwise wish to agree to under the rubric of party autonomy in the context of arbitration. And then there are other jurisdictions, I think, that do allow insolvency to proceed before arbitration, at least in principle, and that don't prohibit the continuation of arbitration when a party enters into bankruptcy. So that is a highly contested issue. related to arbitrability is also, of course, the question of illegality, right? So a contract could be illegal if it is for any number of reasons, right? If it is secured through corruption, if it's procured through bribery, if it's in the United States, sometimes procured through unconscionability or duress, fraud. These are all ways in which a contract could be conceived of as illegal, and these forms of illegality suggest limitations on the concept of party autonomy itself, right? Because the law defines what it means for parties to agree, right? So the law is giving a gloss on what party autonomy means, and this is very related to what you were just saying, right? I mean, to what extent does party autonomy limit future party autonomy, but also to what extent does the law limit the ways that party autonomy can limit party autonomy?
Yeah.
Right, so we have all these different kinds of interactions, and questions of illegality again sort of provide this gloss. So if you have an agreement that is alleged to be procured through corruption, and the tribunal is tasked with making every effort to make sure that the award will later be enforceable, then the tribunal may end up needing to investigate whether the contract was entered into through corruption or bribery. And it may bleed into questions of public policy, which I will leave entirely for your expertise. But these are just ways in which arbitrability and issues of arbitrability and illegality can sort of short circuit these conceptions we have of party autonomy, and echo other ways that parties don't always get to decide which ones of their disputes get to arbitration and which or get to be arbitrated, and likewise get to proceed in the manner that they wish to have them proceed. So another issue of the law sort of offering this gloss on, or a limitation on parties' ability to decide what is arbitrable, is relatedly when they get to decide when they want to decide what kinds of advantages they want to take of court proceedings. So for example, if you want to mix and match your arbitration with more appellate review from courts, there's also limitations on those questions, which are sort of interlaced. So for example, in the Hall Street decision in the United States, parties are not allowed to add to the grounds of vacator for arbitral awards. Parties are not necessarily are not always able to tell the to instruct courts to take advantage of all different sorts of discovery that they might want courts to provide for an arbitral tribunal. And there's a whole debate over whether parties can waive the right to set aside arbitral awards in the future, right? So which of these issues become arbitrable, and what are the aspects of arbitrability that are legal or illegal for parties to agree to? These are all limits on party autonomy that the law may impose. That sort of I think we often take for granted, right? But are there in setting the stage for all of these different issues of arbitration. So I'm ready to stop there if that's great. So thank you again for having me.
Round of applause. We've spoken about the composition, we've looked at arbitrability. We're now going to move on to public policy, the big one in the New York Convention. Professor Cordero-Moss, please take it away.
Thank you very much. This works, yes. Yep. Thank you very much for the introduction. Thank you for having me here, organizing everything. Thank you for coming, for the interesting speeches that arrived and that are going to arrive. I'm going to talk about public policy as a limit on party autonomy, and particularly when it comes to arbitration. Often people believe that public policy isn't really an issue. I mean, it's is there any public policy in commercial transactions? Most of the most of contract law is not mandatory anyway. So how can there be public policy? And then particularly in international arbitration, and they say commercial arbitration, and they say you can, in any case, even if there were some issues of public policy, you could circumvent them easily by choosing an applicable law that is particularly liberal and that permits you the arrangement that you want to achieve. So what is the relevance of public policy? And well, I will make a couple of examples just to show that it's not unthinkable and it's not academic, unrealistic examples where public policy is relevant, and it doesn't really help to circumvent by choosing a particularly favorable law. The most classical example is a contract, a license agreement or some other cooperation where the two competing parties agree to share the market, to fix the prices, you know, the typical things that are illegal because they are against competition law, and we are already starting to talk about illegality. And well, you would say you have agreed to share the market, and then one party does not fulfill its obligations, so the other party starts an arbitration and wants reimbursement of damages for breach of contract. And the defaulting party says, of course, I'm not liable because there is no breach of contract because the contract was invalid under competition law, applicable competition law. And then the other party says, but we chose a different law to govern the contract. So the contract is regulated by the law of, I don't know, Ruritania. Or so I need to be politically correct here. So some country which does not know competition law. So we have exactly chosen that law for this purpose. And so the question for the arbitral tribunal is, do I follow the choice made by the parties and apply the competition law, less law of Ruritania, and conclude that the contract is valid and there was a breach of contract and you have to pay because you are in default? Do I do that? Then I'm following the will of the parties. But of course, if the award has to be enforced in Ruritania, then the courts will say this is against public policy, possibly say this is against, not Ruritania, sorry, the law of Germany, where the defending defaulting party is located, then the German courts will say that this is against public policy because it is against competition law, assuming that there was a serious violation. So this is one example where public policy becomes relevant in a relatively realistic scenario. You have many different examples. Company law can have these sort of implications. Property law can have it, insolvency law can have it, corruption, and you name it. It's a lot of different features that are very often present in commercial transactions. They usually come as incidental questions, as preliminary questions. They are usually not the direct object of the claim, but the claim is usually based on a breach of contract, but the contract is valid or invalid because of these incidental issues. So we see that public policy is relevant, and is relevant also in a context that can be unexpected, that of choice of law. You usually believe that the parties can choose whatever, the law of the Ruritania, and yes, they can, but it can not necessarily always. It does not necessarily always have the effects that the parties wanted it to have. So if the arbitral tribunal is particularly prone to following what the parties have chosen and applies the law of the Ruritania and disregards the applicable competition law, they will render this award. And if the losing party accepts that, of course, then there is no problem. But if the party does not accept it, there is court control, and court control, as you know, can be at the stage of the vacator, it can be at the stage of enforcement, and the courts will take into consideration whatever public policy principle applies in their own law. Even France, that speaks about international public policy, it is the French international public policy. It's not the international public policy. So it's the French public policy that applies in international settings, isn't it? Right. So is that bad? Is that a terrible limitation on party autonomy that we should avoid and try to destroy and circumvent, for example, by going to the courts in France, where the courts have a more liberal approach to a more deferent approach to arbitral awards. My point of view is that this is not a bad limit. It's a limit. It's a narrow limit on party autonomy because it's not that the courts can refuse enforcement over an award or set it aside simply because the law was not respected. It's not a review of the merits. So they are not going to see whether the application of the law was wrong, or whether it was the wrong law that was applied. It's nothing with that. It's a question of verifying whether the result of enforcing the award would be unacceptable, because some very fundamental principles are infringed to such an extent that the court really can't live with that. So it's a very, very narrow defense that you can raise on the basis of public policy, which usually does not really interfere with the discretion of the arbitral tribunal or with party autonomy, as apart from the really serious violation of very important principles. Why do I think that this is not a bad limit on party autonomy? Why do I want to impose on the parties the burden of having to pay attention to what law would be applicable if they had not chosen the law, and to find out whether there are some fundamental principles that could qualify as public policy? Why do I want them to go through this exercise? Because if arbitration is considered this mechanism for dispute resolution that is an accomplice to the parties in circumventing very important policies that the involved states may have, if arbitration is perceived as this area of total freedom where you can disregard any important principles, then arbitration is going to be discredited. Then the trust that the legal systems have in arbitration is going to be eroded. And the trust of the legal system is necessary for the purpose of convincing the courts to enforce arbitral awards and so on, and convincing the courts not to enlarge the scope of what is not arbitrable, because the scope of arbitrability is something that depends on national law. It's not New York Convention or something. So it's the national courts or the legislature who need to be convinced that they can trust arbitration as an accurate way of solving disputes. And if you disregard completely the public policy and the fundamental principles, well, gradually will arbitration lose this trust that they have still, although they are quite under attack, but they still have this trust. So that at the end of the day, permitting some limitations to party autonomy by way of public policy, a narrow limitation like the one that I described, permitting that is more favorable to arbitration in the long term than enforcing anything. Enforcing anything is favorable to that particular award that was enforced, but it's not favorable to arbitration as such. I think I will stop here. I am not sure. I haven't counted the minutes. But,
you're doing good. This is great.
Okay.
Thank you.
Thank you.
Give it a round of applause. Last but not least, Professor Ferrari, who told me to tell you his fun fact is that he is not funny.
Exactly.
That's not true.
You know better. Okay.
Professor Ferrari talks to us about mandatory institutional rules. Professor, do you want to use the podium?
No.
Yeah. Okay.
Thank you very much. So thank you for having me. Thank you, of course, to Daniel Schimmel and Natalie Reed for putting this together and for accepting suggestions as to some of the topics. Now, there is clearly no need to point to the fact that arbitration is an expression of party autonomy. We know it. Still, as we've heard today, there are limits, and there are a lot of limits to party autonomy. In my opinion, this is because arbitration creates a web of relationships between the parties, arbitrators, arbitral institutions, as well as the public at large. Now, some of these interests of these stakeholders may be different, but they may also converge at times. But when they diverge, they create tensions. When they create tensions, these tensions are somehow, through limits to arbitration that exists, solved. Now, we know that there are a multitude of arbitral institutions offering dispute resolution services. Now, to ensure the effective, efficient arbitration proceedings, these institutions have designed, as we know, arbitration rules, which set forth the basic arbitration framework, the basic framework, which, as Professor Bermann mentioned, however, is a framework that is subject to the mandatory rules of the Lex Arbitration. In my opinion, even in France. And while the arbitration rules typically respect party autonomy and grant the parties considerable degree of flexibility to tailor the proceedings as they, meaning the parties, deem appropriate, there are limits to this. Now, most institutions impose certain conditions absent to which they will not administer proceedings at all. It seems, however, counterintuitive that the parties cannot opt out of certain rules which only become applicable if the parties choose to make them applicable in the first place. Pursuant to Article 19 of the ICC rules, for example, parties may only reach agreement on the arbitration procedure, and here I'm quoting, where the rules are silent, unquote. While this requirement is, of course, interpreted rather permissively by the ICC court, by arbitrators, certain features of ICC arbitration are not derogatory. This includes, above all, the involvement of the court. In fact, for example, the court decides on the confirmation or appointment of arbitrators in order to ensure some form of quality control over the constitution of the arbitral tribunal. And we also know that the ICC has refused to administer cases where the parties intended to bypass such requirements. This is a limitation to party autonomy that is in the interest of the parties, of course, and of course the ICC itself. Also, we know that the court will not administer cases in which the parties try to opt out of the core feature referred to earlier of independence and impartiality of arbitrators. As we all know, the court is also responsible for scrutinizing the draft awards provided by the arbitral tribunal, another feature which parties cannot opt out of, and which apparently is imposed upon the parties, both in their interest and, of course, in the interest of the ICC itself, although I have to say, it seems that at times the ICC goes a little too far in the scrutiny process, which may violate Article 34, which the parties have actually agreed. But this scrutiny is geared at enhancing the legal effectiveness, in my opinion, of arbitral awards and identifying any flaws that could potentially put the recognition and enforcement of the award at risk and therefore tarnish the arbitrator's reputation as well as the ICC's reputation. But beyond the involvement of the court, there are other aspects of ICC arbitration, such as its regime on administrative costs or the requirement to sign terms of reference at the outset of the proceedings that are mandatory. And of course, the ICC is not the only institution whose arbitration rules contains such or similar mandatory provisions. Similar limitations also are featured in the rules of other institutions. Just to give you one more example, the SIAC rules from Singapore provide for the possibility of expedited proceedings. We know that. The provisions on expedited proceedings are, however, mandatory. The SIAC rules actually explicitly provide that the expedited procedures shall apply even in cases where the arbitration agreements contains contrary terms. So much for party autonomy. Now, such mandatory rules help, of course, the arbitral institutions. All arbitral institutions build a brand. This means that the transaction costs of identifying a reputable arbitral institution are reduced for consumers of arbitration, which may be a good thing. But technically speaking, however, these mandatory provisions only have a private nature. Let's be truthful. They are not the type of mandatory rules which we all know of from our contract law, for example. They are not created by the state, but by the respective arbitral institution, and the application results from the party's decision to conduct arbitration proceedings under those rules. This is also, in my opinion, why their enforcement mechanism is completely different from that of the more traditional mandatory rules. A provision that is mandatory under such a set of arbitration rules is in fact not necessarily to be considered mandatory by a state court. Let me give an example. The French courts confirmed this in the Nicole decision, in which the court had actually to decide on a set aside that had been rendered under the rules of the Chambre arbitrale maritime de Paris. Why? Because the rules of that institutions provided that challenges of an arbitrator had to be brought within 15 days after the initiation of the arbitral proceedings, and this actually irrespective of whether the respective party had obtained knowledge of the circumstances giving rise to the challenge by that date, which is a little surprising. In fact, the Court of Appeal, in my opinion, unsurprisingly, found that such 15-day deadline was invalid. In the last instance, actually, the Cour de Cassation confirmed the appeals decision. In my opinion, not surprising. But the arbitral tribunal institution's power to monitor and enforce the arbitration rules, in my opinion, is not unfettered. They would like it, but it's not. It reaches its limits, for example, when the parties agree to have a specific set of arbitration rules, such as the ICC rules, administered by a different institution, meaning one other than the ICC. What sounds like a hypothetical scenario has actually occurred on various occasions in practice. In a 2009 decision, the Court of Appeal of Singapore had to assess, in the case in Sigma v. Alstom, an arbitration agreement pursuant to which the SIC was tasked, I quote, to administer an arbitration proceeding under the rules of ICC rules of arbitration. Now, the arbitral tribunal had actually upheld the validity of the arbitration clause in view of the strong arbitration bias. According to the arbitral tribunal, the arbitration agreement was actually not unlawful, even though it was not in line, of course, as we all know, with the ICC rules. In support of this, the arbitral tribunal held that, and I'm quoting again, the rules of an arbitral institution can be legally divorced from the administration of an arbitration by that institution, unquote. It further found that the arbitration agreement was not inoperable, as the SIC had agreed to perform mutatis mutandis the function of the ICC Secretary, the ICC Secretary General, and the ICC Court through actually the SIC Secretariat, the Registrar of SIC, and the SIC Board of Directors. Now, the Court of Appeals of Singapore endorsed the arbitral tribunal's reason. The court rejected the applicant's argument that it would be unacceptable to deal with an inferior, really inferior brand of arbitration. Seriously. According to the court, there was no indication that the parties, when drafting the arbitration agreement, were not familiar with the two different kind of brands, meaning ICC and SIC respectively. Now, the court adopted the same pro-arbitration approach in actually a decision of 2013, in which it upheld an arbitration clause pursuant to which, I quote, disputes should be settled by the arbitration committee at Singapore under the rules of the International Chamber of Commerce, which awards shall be final and binding upon the parties, unquote. Now, while the court noted that there was uncertainty, obviously, as to which arbitral institution would administer the proceedings, it found in that specific case that the parties could approach any arbitral institution in Singapore which would be in a position to actually administer the proceedings under the ICC. Now, actually, the Supreme Court of New York took a similar position in an order of 2014. Still, parties should obviously not be encouraged to derogate from core features of institutional arbitration rules and to agree on rules of one arbitral institution being administered by another arbitral institution. Even where courts enforce arbitration agreements, such as in Singapore or here in New York, providing for the administration of certain arbitration rules by an extraneous arbitral institution, the conduct of such proceedings in such constellations is actually still likely to produce errors. Why? In the earlier case, in the one I mentioned in Sigma v. Alston, for example, a Chinese court denied recognition and enforcement of the award which I mentioned earlier, which was confirmed in Singapore, on the grounds that the composition of the arbitral tribunal had not been in accordance with the agreement of the parties. Why? Because the presiding arbitrator had been appointed by the two co-arbitrators as provided for under the SIC rules and not by the ICC court as provided for by the ICC rules. Now, this constituted, according to the court, an error, according to the Chinese court, and justified non-recognition and non-enforcement, meaning a Pyrrhic victory only. Now, let me conclude. Even in respect of the rules of arbitral institutions, one should not forget the saying, be careful what you wish for, you may get it. You may get all the institutional rules, even those you may not want. Thank you very much.
Daniel, we shouldn't worry about London or DC. This is what we have. One more round of applause for all of them. And folks, we have about 25 minutes, unless you'll want to miss your reception. Ask anything. Now, you can ask both questions and comments. Just keep them brief. It's a question if it ends with the question mark. If it's a comment, if it ends with the period, try to make it 30 seconds or under. Do you want to start and then I'll come to you, but take it away.
Okay. Thank you to the panel for a wonderful.
Just give me 1 second. Greta? Is Greta here? Do we have a mic for the speakers? I can
pretty much project.
The audio will not pick it up. If it doesn't, why don't you just come here, speak, and go back?
Okay, fine. I'll just
Yes.
with one.
And Mike, you can come in the peanut gallery for the next one.
Thank you, Dr. Duggal. Thank you very much to the panel for a wonderful presentation. I've heard this say, and I've had this discussion, that party autonomy is increasingly notional. Notional in the sense that your autonomy is as good as the rules you pick, right? And the beauty of today is that we have academics, we have seasoned practitioners and arbitrators who would pretty much explain this concept. So Professor Bermann outlined a whole checklist of areas where you see limitations and clawbacks on the party autonomy concepts. How do we relate to this notion that in today's arbitration, we should stop telling people that there's actual autonomy, but it's only as good as things get more formalized, more regulated, more rules are coming into place. It's pretty much more of a notional concept as against what we used to know before. Thank you.
Thank you. Any reactions from the panel?
So allow me to say one thing. The moment arbitration proceeding starts, you will see all the limitations to arbitration. The best things that can happen to an arbitration agreement is that it not be triggered. Seriously. You will see, for example, in the pre-award stage, of course, what is arbitrability about? So this is about, of course, protecting the interest of the public at large at the pre-award stage. Of course, we may look at it even at the post-award stage in annulment proceedings, the recognition proceeding, but in my opinion, the limits to party autonomy through arbitrability, for example, manifest themselves early on. And we could go on and use maybe as the timeline of an arbitration proceeding to see how many limits there are. So there's still a lot of autonomy, Stephen, but I still think, yes, there are more limits than parties want to recognize.
Any other reaction from the panel? Please,
Thank you. Of course, I agree with what just has been said. And at the same time, of course, party autonomy is still central to arbitration. There is no question about that. As freedom of contract is central to contract law, probably the line goes where some third parties' interests or some public interests can be involved. The parties are free to determine whatever is an arrangement that suits their interests, whatever balance their interests shall have, whatever regulation and whatever arbitral tribunal and monkeys and whatever. The parties can do that as long as it's only their interests that are affected. As soon as there are third parties' interests, like in insolvency or also the legitimacy of arbitration, and as soon as there is a dimension that is larger than just the interest of the two involved parties, then they should start wondering whether they're, even if they believe very strongly that party autonomy is sovereign and unfettered and so on, they should actually start wondering whether it's not too good to be true. Yeah.
It's not a good idea if Professor Bermann and I decide what to do with Pam Bookman's money, right?
It depends on whom you're giving it to.
So thanks, Kabir, and thanks to the panel for this very interesting discussion today. The question I have is about the interplay between
Not about redheads, is it?
No, it's not about redheads. Not about redheads. I agree. Maybe we should have more arbitrators who are redheads. But my question is about the interplay between kind of party autonomy and international law, particularly ISDS. To what extent does investor state arbitration or even pure international law serve to regulate what states can do vis-a-vis party autonomy, and to what extent should we be mindful of it when having these discussions about party autonomy? I see Professor Bookman, so if you can answer, and I think first, because I think this just hit the core with you. So I'd love to hear your answer first, and then anyone else in the panel.
Right. I mean, so thank you for the question. I mean, I'll just say briefly that in ISDS, I think there's an additional overlay of potential of law that can limit what is arbitrable, that can limit what a tribunal can do, I mean, I just think you're right? That's why I was nodding that, and that it's changing, right? That it may be changing.
Well, I don't know that it's Michael. I don't know that it's measurably more in play than in commercial arbitration. I think among the many things that distinguish commercial and investor state, this is minor compared to some of the other defining differences between them. That's my immediate reaction.
Any other reactions in the panel? No. Okay, next question. Arshia, it's going to suck you right in the background, but please come on out. And so do you want to also join? So we're ready. Ask a tough one.
My question, thank you for the talk. My question particularly was about parties exercising autonomy to waive certain procedures that are essentially beneficial to them, seeking interim relief, award of costs, and maybe even the extent of review of an award. And does the answer change when the parties maybe did not have that much of a say negotiating a contract, such as a consumer contract?
Take it away, Professor.
Well, yeah. It's great to see you here. from the class Thursday. To a certain extent, we might want to protect parties from themselves, and I think that goes to your question. And just in class today, we had this discussion about the fact that in French law you can waive in advance your right to seek vacatur. And that's thought to be, wow, party autonomy, on steroids. You can give up in advance that. That's not really American law so far as we can tell. So we're a little bit more paternalistic about things. So I do think there is some There were some exercises of party autonomy that we don't allow in the interest of them, as opposed to some other thing. The other thing, though, to bear in mind is that this waiver you're talking about, I assume you're contemplating that the parties jointly waive something, because if they unilaterally did, that's a different story. So, yeah, I think we could say, just as an example, our courts will not enforce a provision by which the parties agreed in advance, that they will not, no matter what, seek annulment of an award. I think there's room for that. I don't think there's a great deal of room for that. I think we need to think about what is really essential in doing justice, and what is it that therefore we don't want the parties to agree on. I mean, to the extent we do that, that's a big limitation on party autonomy. But I think it's there, potentially there. I've given you one example. I'm sure Franco and others have others.
What I would like to add is that this ex post control mechanisms that are in place in order to make sure that the award is one you can enforce and don't have to annul, for example, also relate to the expansion, because you just mentioned waiver. The same goes for the expansion of review criteria. Are you allowed to expand them? In some countries you are, in some countries you are actually not. I think that is really a domestic policy issue that each country deals with it in its own way. Let me add to what you said earlier. In Belgium, apparently, if the parties are not from Belgium, they are allowed to fully waive all review. If one Belgian party is actually involved, then it's not possible. So it's a domestic policy issue, and some people believe that makes a country more arbitration friendly than others. I do not think that. You know,
arbitration friendly is the term I get very disturbed about.
We had a conference yesterday, then you, so I agree.
But you know, and I think Giuditta really said it well when she said, it's not pro-arbitration to enforce awards no matter what. Exactly. That's not pro-arbitration. That's short-sighted. I think that was your point, and I think there's a growing awareness of that self-discipline, a degree of self-discipline on the arbitration community is in arbitration's interest.
Right. Sorry. No, just to reinforce, because you in the question you asked about what about consumer contracts, right? Which is, it's also not necessarily pro-arbitration to find every single issue to be arbitrable.
Well, I remember when the Fairness Act, the Arbitration Fairness Act, was first in committee, and it said, you know, you can't arbitrate consumer, employment, civil rights claims. And, you know, a very superficial reaction was, this is bad for arbitration because you're limiting it. And then a moment's reflection will tell you that arbitration is probably better off if some of these things are not arbitrable. And I think the arbitration community has come to that realization.
Allow me to say, abroad, they got this idea 50 years ago. So
Yes. No, I agree with everything that has been said, that actually the interest of arbitration in this is confirming what was being said earlier, that there is a reason for restricting party autonomy, which is not necessarily only protecting the parties from themselves, but it is also protecting the legitimacy of arbitration as a method. So again, it's a situation in which party autonomy is restricted because there is a larger interest than just the party's own interest. Wanted to make build a little bit on the example of Belgium, because I remember, I'm actually so old that I remember when Belgium introduced the law that permitted the party. It was in the 70s. I was a child, but still, still.
But she remembers it.
So they said, they were the first country out doing that. Let's permit the parties to waive completely any sort of challenge to or access to the courts to challenge the award, you will see that all the arbitration parties will flock to the Belgium and so on. What happened was the opposite. Actually, it was very little arbitration already, and then it became even less. So what they did silently, some years after, they changed it. No, because what they did in the 70s, they forbid. It was not that the parties could waive, but there was no review at all for arbitration if the parties were not Belgian. And then they silently moderated it so that the parties could waive, because they found out that that parties, even the parties on steroid and the party autonomy on steroid, even those were rational enough to understand that it was not a good idea, actually.
But you know, France is very proud.
Yeah.
I could stop the sentence right there. Sorry. But France is very proud of that provision. I mean,
It's not the only one. It's not the only
And it's
country.
not the oldest.
No, but they hail it as the epitome. It's the epitome of party autonomy. You know, you can stab yourself. You know, you're free to stab yourself.
Thank you, please.
Thank you to all the panel. Great panel. Now, very briefly, more comments than questions. I mean, I fully agree, Giuditta, when you say that any limitation to party autonomy basically goes for the sake of ensuring the credibility of the institution. I think you're fully right. Just, I mean, there will be so many examples, of course. For example, an appeal against the word, because we're picking so much on French law. Under French law, again with the latest, the decree of 2011, the parties may generally, an appeal against the word is excluded. However, in domestic French arbitration, the parties may nevertheless agree to have an appeal against. In international arbitration, it's always excluded. That's a radical exclusion of party autonomy. Even if the parties did directly or through institutional rules agree to have arbitration, that's always excluded. Then you did not have time to turn into the merits of the mandatory rules vis-a-vis the merits, vis-a-vis substance of the dispute. There is always a typical, usual discussion that we have in Europe with Article 9 of Regulation Rule 1. So the distinction between mandatory and the overriding mandatory rules. Especially, for example, to make things simple, and the parties choose whatever German law, and then what about the power of the tribunal to apply overriding mandatory rules outside from German law, so from a third country, which is not the law of the seat, nor the chosen law, so German law. I mean, I don't mean to open any Pandora box. I'm just saying that it's a huge topic, and thank you.
Thank you. Well done.
You're right in the front.
Again, thank you very much. My name is Usher Wenslet. For those who I haven't met, I'm an arbitrator based in New York. I have a question about providing for limits in an arbitration clause that would not be allowed otherwise. The arbitration, let's say it's an ad hoc arbitration, so there's no institution to come in and change this, and the parties provide that the arbitrator, that all arbitrators must be, or the arbitrator must be a straight white Anglo-Saxon male. So obviously it's not going to come up until somebody challenges the award. So what happens?
Well, you know, if I can just very quickly, because I was cut short in my previous, I was actually going to touch on that, because it is a question of whether parties can agree to exclude certain categories. And in American constitutional law, we'd say it's invidious discrimination. So you can discriminate against blondes and dark-haired in favor of redheads. But when it comes to race, when it comes to ethnicity, and when it comes to gender, when it comes to sexual orientation, and any other one of these categories, I would add age, by the way. I think there's a very strong likelihood that certainly that agreement will not be enforced. If it is, and there is an award, I think that award is in peril.
I would agree. In fact, we have cases where labor laws came into play in some countries in Europe, of course, at the annulment stage, even at the recognition and enforcement stage. In fact, the strange case mentioned earlier by George, the English case, was a case where that was possible only because the subject matter had to deal with kosher food. So that's why it was okay to actually restrict the arbitrators to arbitrators of a given phase, because they would be the ones to know. So that's why it was possible. But otherwise, I would think it is not a workable solution. So you will get problems at the enforcement stage, if not even at the annulment stage.
I can't resist, since you're referring to that case. The argument was made that restricting the pool is contrary to union employment law. Yeah. And this is just really wild. And the question was, is the arbitrator party relationship an employment relationship? Now, the English court had no difficulty saying, no, they do not, they're not employer-employee. And then they went on to say in dictum, which is important. I always say, pay attention to dictum, because it didn't have to be said, right? The dictum was, look, there can be a bona fide, because that's usually the term, a bona fide, genuine rationale for, and in this case, it was the subject matter of the dispute.
Just, it's actually an anecdote. Employment law in Norway, where I am, if you get when you get paid the fee as an arbitrator, it is paid as an employment fee, as a wage, actually. So you have to pay taxes and as if it was your wage.
Even the other people have to pay taxes, even if you are not in Norway.
But the point is that when you are when you're having an international arbitration, and you are the only Norwegian arbitrator, and then it shows the fees. The others, they get the fee, and you get salary, and they wonder, were you employed by the party? And I say, of course not, but it's our tax authorities.
We're almost at time. I know this is a very fun discussion, and we can keep going on, but I think we should stop. So let me just invite everyone to give a round of applause to this awesome panel.